Hello, 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 hello. Another episode of the Serenity Resource Connector. We go live each Thursday at 3 p.m. Central Standard Time. And whether you're joining us live or you're watching the rebroadcast, it is a pleasure to have you here. So we've been having a series of virtual hand-holding for those who are looking to get into business or probably just started. And so we started off by looking at the things you need to consider before you step into business. Then we moved into looking at some of the license that you require to start a business. Then we had conversations with the representatives from the company's office explaining to you the different options that you have to register your business, whether you're registering a sole proprietorship, partnership, or company. And there were so many things that the rep from the company's office shared. And then we moved into looking at after the registration with the company's office, what's next? And so we had our team from the tax administration department, as well as the National Housing Trust, sharing on what you do after you register your business so that you become compliant and what you need to do to remain compliant. So just in case you missed those and other previous episodes, not to worry, they are available on YouTube at Winsome Sharia Witter. That's either where you're watching from, or you might be watching from the Facebook page, or simply Google Serenity Resource Connector and you'll be able to access the playlist. So you can get access to all of that information as to how to get started in business and remain compliant. So for this afternoon, this episode, we're turning our attention to another entity that you need to connect with after you register your business. But it's not just for those who are operating a business. If you're a professional, if you're operating in the digital space at all, each day we create, we produce things and we share. But how much do we know about intellectual property rights and how to protect them? Because rights comes with responsibility and with the protection. So our guest for this week will be from the Jamaica Intellectual Property Office, otherwise known as JIPO. We are going to take a quick look again at this promo as we appreciate our partners that made this episode possible, as we wait for guests to join us on set to share information. So let's take a look at what the Serenity Resource Connector is all about as we wait on our guest from JIPO. Right. Thank you so much for joining us for this episode of the Serenity Resource Connector as we welcome our representative from the Jamaica Intellectual Property Office in the person of Herman Dawson, Assistant Manager, Trademarks, Designs, and Geographical Indications Directorate. I've been seeing what looks like some new things for JIPO because I've been doing some research over the years. So I'm gonna ask Sir Dawson if you could go ahead and tell us what the Jamaica Intellectual Property Office is all about and what exactly do you do? Right. You're muted. Let's unmute.
Sorry about that, the
That's
technology.
all right.
All right,
It
good day,
happens.
good day to you, and thanks for having us to join you in this important work of public education. Good day to your listeners as well, or to the persons who are streaming the video today. Uh, JIPO, the Jamaica Intellectual Property Office. We have been about from 2002, carrying out the important mandate for the government as it relates to intellectual property administrations, providing the systems so to allow creators and inventors the opportunity to protect their intellectual property. We have the critical mandate of advising the minister from time to time as it relates to IP matters, and to provide sort of system that is comparable to international systems that allows persons to register their trademarks, to register their designs, to an avenue to protect their works, whether it be a copyright or an invention as well. We also have a relatively new era of geographical indication that comes under industrial property. So intellectual property as a broad heading covers different eras for persons to protect their own intellectual creativity and works.
Okay. Yes, because that one popped out at me because I'm like, I've never seen this particular one before.
Which
When
one is
I did,
that?
that's the that one you just mentioned just now, the geographical indications.
Indication, right, 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 right.
Right. So we are learning together. Right. So in outside of that, there are some other areas. Traditional knowledge, was that one always there?
No, no, that is also relatively new. Traditional knowledge and cultural expressions, essentially, it protects the know-how, the ways, the sayings, the way how traditional people express themselves or carry out certain activities. And it's particularly for indigenous groups such as Rastafarian community and the Maroon community. So embedded in the law, well, it was a policy, still a policy, but it has now been special provisions have been made for it in our trade in the recent amendments to the Trademarks Act that gives legislative protection to traditional knowledge and cultural expressions of these indigenous groups. So if you were to apply, for example, for a trademark, an application to register your trademark, and your trademark included certain themes or colors, words that are associated with certain traditional groups, such as the indigenous groups, rather, such as the Rastafarian or the Maroon community, then the normal response from the office is a rejection letter, unless you can prove that you are connected with such groups or you have permission or consent from any of the indigenous groups to register that trademark. So it is giving some level of protection to these indigenous groups.
Awesome. That's really interesting. And it's great to know that we can have that kind of protection because that is very important. All right.
Certainly.
Yes. So there are different areas because typically when we are thinking about, in general, we usually just say copyright, but then we have
Mm-hmm.
copyright and we also have trademarks and patents and so on. Can you give us a briefing on those and what are some of the areas that will be covered under the different categories?
Certainly, and you are right. You are definitely right. We have come across a number of persons from time to time. Everything is copyright. I'm going to
Everything.
copyright this. I'm going to copyright that. So
Yes.
we have to painstakingly take them through the process and to let them know what's the difference between trademarks, between designs, copyright, patent, GIs, etc. So let me start with copyright. Copyright essentially covers a bundle of legal rights that one has over certain creations or certain things that they have created. And under the Copyright Act, it speaks to a work. All right. And your work can be a musical work, it can be artistic work, it can be a dramatical piece, it can be a film, it could be a documentary, it could be a movie, uh, literary works, those things that have an where there is an expression, but it's not just a word. It's a body of work that you have. So if you wrote a poem, for example, that's not just one word. All right. It has some artistic element to it. So if you wrote a poem, the poem would be protected under copyright law. If you took a
Right.
photograph, for example, the photograph would be protected under copyright law. If you did a drawing or a sketch, you created a computer program, you wrote a novel or a book, you have a song, you wrote the lyrics, those are protected under copyright law. So once you create an original work and it's expressed in a tangible form, you have automatic right to that work and it's protected under copyright law. So the creator of the work has copyright in the work unless there is an agreement to the contrary. All right. So normally the first owner of the work is the person who created the work, unless there's an agreement to the contrary. Now, if I am to move on to trademarks now, which is one of the most common areas where we
Before
see
you
under,
move on, before you move on to trademark,
sure.
how do we determine who is the original creator of the work?
Well, essentially, it's all about evidence. All right. There's no requirement under the law for you to register a work under copyright law to obtain protection. What you then have to do as the owner slash author of the work is to be able to be in a position to prove ownership. And we recommend that along with the copyright notice, which is the word copyright, sometimes a small C in the circle, which you'll see
Right.
from time to time on different media, or you see it on books or CDs, the name of the owner slash author and the year. So you will see this many times over. At the end of the news broadcast, every evening, you will see copyright and a certain media house name and the
Right.
year. That is an indication that this company or entity is claiming copyright in the broadcast that you have just seen. All right. Now, it is not a situation where these media houses would come to JIPO every day to register to say that, okay, I have copyright in this.
Yes.
No, the law doesn't require registration. All you have to do is to be able to prove that you created it. So if someone is challenging the authorship or ownership of your work, then you should be in a position to prove by having evidence. One of the simplest ways of evidentiary creation that we ask persons to use is what many call poor man's copyright. It is where you register mail a copy of the work to yourself, to your post office by registered mail. So you're basically sending the work to your own address by registered mail. When that mail comes back to you, you keep it in a safe place. You never open it. That is your evidence, and you can present that in a court of law in the case ownership is at dispute. All right.
Yes. So
We
that's for the printed matter.
That's
Now
a
we're
printed
operating in
matter
the
for
digital space.
right, but for any matter it is. Even if you create a computer software or a program, we know that the programmers will have the codes to
The
the to the
codes,
to the
right?
program. So it's very unlikely that someone else will have the codes unless they stole it. All right, or something underhanded went on. But once you're the program and you have the codes, then you can prove that you created the work. So even if it's a soft copy or an online, if you go on many websites now, you will see the same copyright notice I'm telling you about.
Right.
Copyright, the small C in the circle, the name of the entity or person who claims copyright in it. They then must be in a position to prove that, okay, I created this. At JIPO, we do have a voluntary deposit system. The copyright law was amended to facilitate this, where you can deposit a copy of your work, but it's only for evidential purposes. We're
Okay.
not doing a search, we're not examining the work, we're not validating it in any sense to say that, okay, yes, you have copyright in it, because JIPO doesn't have the resources. It's not our mandate to go out and search to make sure, okay, you actually took this photograph, you actually wrote this poem. We can't do that. So we're acknowledging by your deposit and your form that you've filled out that you have done in good faith and paid your fees that you are making a claim to copyright. And that certificate can be used in court for evidentiary purposes again. So again, it's simply for having evidence that you created the work. Some persons will say that they will email a copy to themselves, or they will fax a copy, any form of evidence that the court is willing to recognize, or you can put forward to the court in a manner that the court recognize, then that would go well against in a case of an infringement proceeding.
Okay. Before you move on to the next one, video. So that emailing to yourself, would that be like videos and so on?
Right, you could do that as well. And again, JIPO does have that system where when you bring a copy for evidential purposes, it's a soft format that we need. So you'd bring the video on a CD or on a flash drive, and then we take it off and we store it for you for evidential purposes. But yeah, you could email it to yourself. I know persons have a way how to date stamp and name stamp certain things, to encrypt certain materials in it so that people can know who created the work, etc., etc. So again, it's simply having evidence. No registration is required under our law for you to have copyright in a particular work that you would have created.
Okay. As Sher is saying, interesting. All right. So we have persons joining us from this person's on YouTube, and we have persons on Facebook as well that's joining. All
That's
right.
good.
All right. So that's copyright. So we're moving on to patent next. Tell us about that
Well,
one.
well, all right. If you want to go on to patenting, so a patent really is an exclusive right that is given to an inventor for an invention. And an invention really is any new and useful product or process. So quite simply, an invention is a technical solution to a problem. All right.
Right.
So if you think about items such as your pharmaceutical items, they are said to, you can get a patent on them, sorry, if they are solving a problem. Some are solving COVID. Well, we're told, yes, and some are solving hypertension. Some maybe treating cancer, treating all sorts of diseases. So it's a function. You do have simple patents, though. The zipper that you have on your clothing, that was subject to a patent many years ago. The Velcro was subject to a patent as well. So it's anything that you can use to solve a problem. A technical solution. From time to time, when I give my presentations to especially students, one of the things I always say to them that I'm waiting on someone to come up with a device that can help me to peel green bananas much easier, you know. I'm still waiting on that one, you know, because I
It's
don't
not
like
that
peeling green
difficult,
bananas.
is it?
No, I don't like
Or
peeling
you
green
just don't want to
bananas,
get the
honestly.
skin on your hand.
Yeah. So
There are
just
ways
like
around that, you know.
I know. I heard people say I must peel it in the skin and cook it in the skin, etc., etc. So
Or put
I
some
mean,
oil on your hand before you
yeah, I do that
clean
too,
and
but
so.
still, you know, that's the thing, you know. I mean, it is said that um there's a quote, I can't remember it, about the mother, necessity is the mother
Oh,
of all
necessity is
invention.
the mother
Yes,
of all invention.
exactly. So when we come up with these needs, that's when we have these solutions.
Okay.
But essentially, they're technical solutions to our problems. So the intellectual property on a whole is all around us. The things, the cars that we drive, the computer that we're using right now, or the phones, inventions are all in them. All right, and somebody would have created it. And the IP systems are allowing creators, inventors to protect their intellectual property. And
Right.
quite when you register for industrial property on a whole, which is, let me just say, so you have intellectual property at the helm, and then under intellectual property, you have two subheadings. You have copyright and related rights, which I just spoke about mainly for copyright. And then you have industrial property. So copyright, industrial property, two subheadings. And then under
Right.
industrial property now, you have your trademarks, your designs, your patents. Those require registration for the most part. And for you to ensure that you have protection, then it is best to acquire registration. So systems are in place for you to register your industrial property. All right, but for copyright as a subheading does not require registration for you to obtain
Okay.
protection. All right. So Right. So that's it for patent. It's unfortunately patent is one of the least used areas of IP. Certainly, when we compare the IP systems are available here, patents are the least used, and it's the
Okay.
cheapest. To be quite frank with you, the law is really old, and so
Okay.
to register a patent or to file for a patent is like $3 Jamaican. It's I think it's an 1837 act. So
That's
the act is very old, but we are moving ahead to have the amendments done so that we are up to date and so that we can join PCT, which is the Patent Corporation Treaty, which will allow Jamaicans who have patents to seek registration of their invention in other jurisdictions.
okay. So what about the different apps that are created? Those would fall under patent as well?
No, they would fall under copyright because copyright would
Right.
speak to computer
Oh,
programs
because
as
it's
well.
okay, similar.
Right.
Okay, in terms
Yeah.
of the okay. Um, Trademarks.
Right. So trademarks, quite interestingly, is we're seeing like it's the most used system that we have
Imagine
at
so. Yes.
JIPO, because when people come up with new products, they come up with a name as well for the product, and that name can be registered as a trademark. No, not all names are registrable. Naturally, we must do a search and an examination
Right.
to make sure that the name one is not is available, it's not being used by anyone else at our registry, and that it satisfies the requirements under the Trademarks Act and the Trademarks rules.
Mhm.
The trademark essentially, though, is a sign that is used to distinguish your goods or your services from others in the marketplace. So a sign can be letters, it can be words, it can be even one letter. It can be words, it can be numerals, it can be a packaging, it can be the shape of packaging, it can be a name that it must be unique to some extent to be distinguishing your goods and your services. And we see them all around. I'm seeing one right now. I see you have Serenity Resource
Serenity.
Connector. That is a
Yes.
trademark, all right? And
Right.
you would use that to distinguish your services from your competitor services. And once you register a trademark, it is registered for 10 years and you can renew. So the trademark registration can last as long as you continue to renew the registration. And again, importantly, I must say for our viewers that once you register a trademark, it is only protected in the country that you have acquired registration.
It's important.
Right. So you
Yes.
can't think that once you register in Jamaica, your protection is extended to other jurisdictions. We have a large percentage of our trademarks in Jamaica are filed by overseas applicants. So persons recognize the importance in having the protection in the different states or countries that they are desirous of having protection.
Right. Because for persons who are not international and they
Mhm.
want to distribute a goods or service here, if it is that we already have that name and that mark here, then they would not be able to do so, even if they are
Certainly.
registered in their jurisdiction in the United States or wherever else.
Absolutely, absolutely, absolutely. So if
Right,
you, yes, if you have that trademark registered and they're trying to sell their products or offer their services here, then that may amount to an infringement because you would have had the registration here first. So, and it's important then, we recommend highly that if you're exporting your products, you have your trademark registered in Jamaica and you're exporting your products to any other country, that you do a clearance search. Make sure that trademark is not being used in that jurisdiction before you start exporting your products there, because you don't want anything to happen and then there's an injunction and you can't sell those products and you lose all that money. So you
right,
try and do at least a clearance search, even if you're not going to apply for registration, which we still recommend that you do, but you do a clearance search to make sure that that name or mark is not already registered to any entity in that jurisdiction.
right. Because not just that, can be a very expensive legal process if someone
Absolutely,
there, yes, decide to
absolutely,
take it up.
absolutely,
Because I'm
absolutely.
not right. I'm not remembering the specifics now, but I know of a couple of cases in the past where international entities have sought to claim names that are being used here in Jamaica. Not remembering the specifics right now, but I know that there are a couple of cases. I think at one point it had to do with the person's legal name, That was the
Right, right. I believe the case that you're referring to is the McDonald's case, right?
McDonald's. That's it.
McDonald's, right,
Yes.
where you had a legal entity registered here using the name McDonald's, and then when the international chain came, there was a legal dispute over that. I don't want to speak to that too much because I'm not fully off with that case, but I believe that the local McDonald's was able to prevail, uh, despite, because once you have a registered company, I don't think that company had a registered trademark, but the company was indeed registered, and by virtue of having a registered company, you are legally allowed to use that name to trade it, to do your business.
Right. That was would be my next question in terms of which is why it's important to do the registration at the company's office, and then the
Right,
next would be come to JIPO to register if you're going to do your trademark and
right, right.
a copyright or a patent associated with
Right,
that.
absolutely. And we find that persons tend to register the company. I'm not sure what is the rationale or the reason for persons be more willing to register the company at the company's office. One school of thought is that because the company registration or the Companies Act makes it mandatory for you to register your entity once you're offering business. Unlike the Trademarks Act, where it's not compulsory, it's an option that you have to register, an important option nonetheless, because you don't want to not register your trademark and then you run into a situation where you have to fight to get it back. Uh, but yes, certainly when you register your company or your business at the company's office, you should come to JIPO and register your trademark. And quite frankly, I believe that every company that has a name also has a trademark. All right. The
Yes.
same name for your company or the same name for your business is also your trademark. And it's particularly important when you have a logo or an image or some artwork that goes with that name. That signifies that you have a trademark. So some persons may not even recognize that they have a trademark. And simply, it's a mark that you use in trade. All right. So that symbol, that artwork that goes along with the name of your business, that is your trademark, and that what is it needs to be registered. Also, you have companies that will have several names of products. All right, those names of the different products are not company names, are not business names, so to speak.
Right.
They are trademarks because you're using them to distinguish your products or your services. All right, so if I have a company and I am doing Herman Dawson Limited, all right, and I am doing some juices, and I call my juice Herman. Herman alone would be my trademark. It's not a business name. I would go to JIPO to register Herman as a trademark for juices. If I also have Dawson and I'm using Dawson for some pastry items, then Dawson would be my second trademark, and that would be registered for pastry items. So you
Right.
similarly to where you go to the company's office and in registering your business or your company, you have to list the type of products or the nature of the services that you'll be offering.
Right.
It's a similar process for us, but our services and goods are classified based on an international classification system called the NICE classification, where each class, literally from classes 1 to 45, literally have a different set of goods or services. So you will register your trademark in the class or classes that covers the goods and or services that you will be using the trademark in relation to.
Oh, that's important. And of course, the documents I've been using them, looking at them, so I know that they clearly outlines how exactly to get it done. And the staff at JIPO, they are really sweet when you call. They're very helpful.
Yes, yes, very
Yes.
well.
So
Mhm.
yes. So if you're not clear on it, then you can always get support. And the
Right.
awesome thing is that JIPO has adopted the electronic medium for you to do your registration and to make your payment and submit. I love that. I love convenience.
Right, 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 right.
Yes.
Well, I am, I must say, we're in light of the advent of COVID, we've tried to adapt and to make life easier as best as possible for our applicants and our clients. What we recognize, though, is that what we're trying to achieve is something that is far better than what is available now, where it's a online system. Right now, we do not classify what we're providing as an online system. What we're doing is facilitating the soft copy of the application in the interim. So we allow persons to pay into our bank account. And we ask, though, we find that there's a little bit of challenge with that, because some persons pay into a bank account and they don't follow up. You can't pay into a bank account and then you don't follow up. You won't know what it is for because a number of persons are making the same payment every day. All right, so we
Right.
need persons to follow up so we can identify the payment. But yes, we make that facility available where you can pay into the bank account, print your form, scan it, and send it to us via email, and we will process it from there. But ultimately, as I was saying, we're working on a platform where you can go on our website, key in the information that you want, and then pay using your credit card and submit your application. That would be a fully online system. So we're
That's
working on that to make life easier as well. Also, to make it possible for you to do a search online. Currently, we can do
awesome.
a search for you, and you pay, or we do have persons being able to come in and do the search at the time, but under observing the COVID protocols, of course. All right, but some persons do prefer to have us do the search, and we send the results to them, and then they make a determination from that. In addition to that, we also have a preliminary search and advice procedure. So if you have a mark and you're not certain of the acceptability of that mark, you can pay JIPO to search and examine that name for you and advise you as to whether that mark would be acceptable by the registry. This is important. Why? Because when you apply for a trademark, and any one class you apply for, or any class that you apply for, it's $7,800 to apply for registration. I'm not sure if you did, but it's $7,800 for the first class. And if you're doing
Right.
additional classes, you pay $2,200. When you pay your initial fees, the office must do its own search, but that search is after you've submitted the application. If we, for any reason at all under the law, refuse your application, the first fee that you pay is non-refundable. In fact, none of our fees are refundable. So persons who want to be assured that yes, JIPO is prepared to accept their application, those are the persons who may opt to do our preliminary search and registrar's advice. But you do have persons who believe that, okay, my mark is so unique, nobody's thinking like me, I want to go ahead and apply. I'm not paying JIPO $2,200 to do a search. I'm just going to apply. For those persons, you're free to do that. You can just submit your application with confidence and just be prepared if JIPO accept or reject it, so you can deal with it from there. But that's the option available for persons.
All right. All right.
Uh,
Quite a yes. Go ahead.
right. I was going to move on to designs.
Yes,
All right,
that's
because right.
what I'm
So
thinking next.
right. So a design essentially is how a product looks. It's the outward appearance, the aesthetic features of a product. It doesn't protect the function of a product. Patent is what protects the function of a product. But for design law, it basically protects how a product looks. So if you're a lady and you like handbags and you design a handbag, the handbag doesn't really have a function because they all do the same thing. You carry personal items or your items in them. But
Right.
how they look in terms of the shape or the pattern that you put on them, that could be a design protection. Clothing, design protection. All right, your shoes, design protection. Earrings, jewelry, the shape of the car could be design protection as well. Your furniture in your home, the fridge, the phone case, the outer appearance of the phone, every product that you can think of, the outer appearance of it may be the subject of a design protection. So essentially, it's really how it looks. Um, Even food items can be design protected under design law. There is a patty that I know people love very, very much that is subject to design protection. So if you come up with your own shape for your patty, you could get design protection for that. As long as it's novel and it's new, then you would be
Okay.
able to, and it's original, then you can get you may be able to acquire design registration for that product. And we realize that we do get a lot of applications for design in relation to sandals. So we have a
Ah,
number of persons that are doing sandals, and they are coming up with their own original designs, and they're applying to have them registered. So even patterns that you see on shirts, a number of persons will come up with different sayings and designs for the front of their t-shirts. Those can be subject to design protection as well, as long as again they're original and they are new, never been used in the island before. You may be to acquire design protection for them. So almost you can have design intellectual property in many aspects of IP in one product. So in one product, you could have a trademark, you could have design, and you could have patent. You could also have copyright in that one product, because the advertising materials that you create to promote the
Right.
product would be subject to copyright protection. All right. I know one good example that we tend to use is a motor vehicle. All the technology inside could be subject to a patent. The
Right.
name that goes on the grill is a trademark. The shape of the car would be designed. All right. And
Design.
again, the materials that you create in terms of advertising and promotion would be subject to copyright protection. So intellectual property, it's a great area. It's all around us. Everything that we use today is subject to some level of intellectual property. And
Right.
we encourage persons to be respectful of IP. If you create IP, you want to register, to have it protected, and to exploit it so that you can make as much money as you can, and it can lead to development as well.
Indeed. And that's why we want to ensure that persons are aware of how they, what the different rights are and how they can protect them. Because
Right.
going back to copyright, because this is one of the maybe the widest area. When
Right.
you talk about, especially now, I want you to address in terms of our educators, because a number of our educators are offering online learning, so they spend time developing their program, and then they're have it out there. But if they do not go that extra mile to protect what it is that they spend hours or maybe months creating,
Right.
what kind of guidance can you offer to our educators?
Well, again, as indicated previously, once you create an original work under copyright law, it's automatically protected, so registration is not required. So essentially, if you create something that is original, you want to be able to put your name on it. Always put the copyright notice on your work. Once it's yours, somebody should know that it is yours. So if I see it online or I see a physical copy of it, then I should know that Herman Dawson, for example, is claiming copyright in this. So if you create a manual, you create an online program. When I view that program, I should see, okay, that this person, John Brown, claims copyright in this work from 2020 or from 2021. I then should be in a position to prove ownership if ownership is being challenged. All right. Again, you can register, mail a copy of it to yourself to your local post office. Two, you can use JIPO's voluntary deposit system to get a certificate to show that you have deposited this at JIPO on this particular day, and which can be used in a court of law in case there's an infringement proceeding taking place. All right. So essentially, you want to be in a position to prove ownership. If it is that you have any challenges, obviously, IP rights are personal rights that you have to enforce. So where you perceive that your rights are being infringed upon, then it's for you as the rights holder to use the provisions available under the law to enforce your rights. So always you seek legal consultation, get guidance, and to see what recourse do I have under the law, all right, as it relates to the protection of my intellectual property.
Right. Because unless that kind of due diligence is done in terms of the poor man copyright or having
The
JIPO,
voluntary, right?
right, then it's all boils down to who can prove that they actually created first, even though,
Certainly, certainly,
yes.
certainly, and it also depends on your contract as well. As someone who is employed to an entity, it also depends on what the contracts that you sign. If there an IP component to it that speaks to intellectual property that is created while you're employed, then you also have to look at that. Remember, initially when I was saying that it is the first owner is the person who created the work, unless there is
Right.
an agreement to the contrary. So we need to be mindful of what clauses we have in our contracts.
Okay, yes, because going back to the educators, because depending on what's in their contractual arrangement, they can basically be signing away their rights.
Absolutely,
So,
absolutely.
right, so they have to pay attention to the fine prints. We have
Right.
we have seen it happen over the years too, especially our artists,
Mm-hmm.
our musicians, right? So in terms of their signing away their rights, because they have these managers that give them these detailed documents, and in the fine print is there to say that they are basically signing over their rights. So we have to pay attention to those fine prints.
Right, certainly, and we as always, as best as possible, seek legal guidance. Get someone to read over the contract for you, someone who is looking out for your interest, all right,
That's
and
right.
who can read the document and ensure that your rights are being preserved and protected.
Indeed. Right. For or is there an age limit as it relates to who can register in any of these areas? What age does the
Well,
person have to be?
the I don't believe the law allows an age limit, um, but what we do is that where the person is a minor for a trademark, for example, if you're applying to register a trademark where the person is a minor, we ask that a parent or guardian also signs the application with that parent, with that child or
Okay,
minor.
right.
All right.
Because I
So,
know
and that
that
would
we have,
apply for designs as well.
yes, because I know that we have a number of minors who have gotten started as it relates to when I went on and I saw the think, imagine, create. I'm like, okay,
Right,
JIPO.
right,
When you think
right,
it, once you imagine it and you create it, then
right.
you need to copyright or protect
Protect
it
it,
rather.
protected,
Protect
protected,
it.
protected.
You need
Certainly protected.
you need to
Right,
protect it, right? And
definitely.
yes, and that goes for so many of us because even in sharing on our social media platforms, because there are many cases where um, there are some work that's shared on your platform and then you see it popping up elsewhere and persons
Hmm.
creative they crop out the if it is that you have actually gone ahead to design something with their name in it they crop it out so
Right.
only like I remember specifically I done a quote several quotes and I saw it pop up on I think it's a Google search someone
Hmm.
actually used the quote, cropped it to remove the name, and the quote was there. I'm like, this design looks familiar. This quote sounds familiar.
Right, right,
Right.
right.
Yes. And there are several persons who have shared too that they've actually shared large bodies of work on their social media platform only for someone else to claim it and copyright it and so
Hmm.
they actually lose the right to it because they really didn't take any step to
I'm
protect.
I'm not certain why they would say they would lose the right to it, because what it would require for them to do is to seek some legal guidance as to how they can go about to enforce their rights, because it is their rights. The copyright belongs to them. They are the original creators of the work. Sometimes it may be
Right.
that persons are frustrated and take a laid back approach. They can't bother with the legal fees to fight the battle, but we're giving up our rights when we do that. And these people are getting away with that if that is so the case. But once we create an original work, putting it online, it's a global marketplace, then it becomes
Yes.
open to the world to use, to manipulate. But we have to be prepared once we create our work to enforce it. All right, enforce whatever rights that we have in the work. Sometimes it's really just to send the person a cease and desist letter or to make a report to the social media houses, the Facebook, the Instagram, if those are the platforms that are being used, to report these things to them and ask them to take some action in removing. All right, if you know where the person is, then you probably can speak to an attorney and get that attorney to start some proceedings, to get back your work or to ensure that it's not being used. In Jamaica, I know that we attorneys will send cease and desist letters all the time to persons to stop using a particular work or product or brand. And if that doesn't work, then you go seek redress to the court. You can get injunctions through the court, and if the situation goes to the full length of a court case, then it could be awarded damages and all the other remedies that are provided within the different legislation.
Indeed. And then there are several entities out there that can assist with that kind of monitoring as well, because I know you have the jam copy, have the Jams, the Music Society, and they have
JCAP.
extensive JCAP, and they have their systems in place where they can do the monitoring and assign royalties and all of that. But that's another conversation, unless you have something to share on that.
Well, essentially, just quickly, they are collective management organizations, and they assist different rights holders to help in collectively managing your rights or your work. I mean, most of our entertainers do not have the resources to monitor the platform, the different platforms, to see who's using their work and to go behind persons to get royalties. So what you do, you join these collective management organizations with regard as it relates to what aspect of the work you're involved in, whether you're a producer, you're a publisher, you deal with them accordingly. But essentially, once it involves your work being used, you are to be paid for it. So these entities, they help to manage the rights and to provide you with royalties for the use of your work. All over the world, countries will have their own jams, their own JCAP, their own jam copy. So they work
Right.
together, or they pool and they work together, and royalties are sent all over the world. Some persons will have issues, I'm sure, while some others will have good stories about the benefits that they have received. It's not a perfect system, I'm sure, but it's a
Right.
system nonetheless that provides an avenue where persons can be paid for the use of their work whenever it occurs. If, for example, your work is to be used in a movie or some documentary, if they can't get in touch with you, then they get in touch with the licensing agency, who will then speak on your behalf once you're a member, because they represent you, all right,
Right.
and they can facilitate licensing of your work as well, and then ensure that you are paid for the use of that work. So they help to collectively manage the rights in your work. Jam copy, JCAP, as well as jams.
All right. Because in previous years, well, it's wearing another hat, we had the whole matter of why the different entities and all of that. But now it's getting clearer,
Right, right.
especially in this digital era. You
Mm-hmm.
get to understand the importance of having these, because I mean, your work can be used by the second all over the
Certainly.
world, and with that, this kind of robust system that they have, they're able to pick up these and ensure that those one penny adds up.
It does, certainly, certainly.
Right. Well, this is really great conversation. And there's so many other areas as it relates to the full gamut of the different rights, and as it relates to the digital space, and how we
Hmm.
can not only protect our rights but respect other people's rights as well, because it
Certainly.
goes both ways. Right.
Right.
Yes.
I
Go ahead.
I I, I was I didn't get to mention and you spoke about it earlier, and that it was a new era that apparently were quite fascinated with, in terms of the geographical indications.
Yes.
Right. So GI is relatively new to us. The Essentially, a geographical indication is a name of a place where the products, generally, it normally starts out with products, and for the most of the GIs are in relation to products, where you can have a GI for services, but for the most they are in relation to products, where the products themselves are said to acquire certain qualities or attributes or characteristics from that place. All right. So persons tend to ask if certain names that we see on products here, certain geographical names that we see on products here, if they could be a GI. There could be a GI, so long as you are able to prove that there's a link between the quality of the product and the geographical area.
Okay.
So either through the soil, the climate, or the know-how of the people, there has to be a direct link to the quality and characteristics of the product. And quite when we speak about GI, one of the most famous names that comes to mind is the Blue
Blue
Mountain Coffee.
Mountain.
All
That's the
right,
first. Yes.
right. And our coffee, it fetches a premium price on the world stage because of that quality, and that quality certainly comes from the soil, the climate, the altitude, of where the coffee is grown and how it is done, the know-how of the people, that creates that certain level of quality, high quality that we know and have become accustomed to for our Blue Mountain coffee. On the worldwide stage, though, we have other GIs. Champagne is one of the famous GIs as well. A lot of persons may not know, a lot do know, that Champagne comes from the Champagne region in France. Okay, so it's a place that is called Champagne. So if you're drinking anything and it doesn't come from Champagne, it must not be called Champagne. It should be called sparkling wine.
Sparkling
All
wine.
right. So if it comes from any other country, it should be sparkling wine, not champagne. Champagne must only come from the Champagne region in France. Tequila as well is another example. Tequila must come from Mexico. And there's an area in Mexico that is called tequila. And the great thing about these is that the products come from that area, and the product has certain features that is just endemic. It's systemic to the place where it comes from. All right, the climate, again, the soil, etc. We have two, I believe, two Jamaican GIs that are registered. Blue Mountain Coffee has not been registered as a GI as yet, but it is still serving its function as a GI. It is a certification trademark, which some people compare to GIs,
Yeah,
but there are
okay.
differences. We have the Jamaica rum. Jamaica rum
Yes.
is a GI. It's a registered geographical indication in Jamaica, and it's registered. We have the Jamaica jerk also is a geographical indication. So they are both registered to their respective associations, and
Okay.
it allows persons, if you want to use Jamaica rum, you're a rum producer and you want to use Jamaica rum on your products, you must be a part of the association. You must satisfy the rules and the regulations that are set by the association in defining and ensuring that your product meets the requirements to be designated Jamaica rum. Likewise for Jamaica jerk. If you want to use Jamaica jerk on your products, your jerk sauce, whatever, and you want to say Jamaica jerk, it must satisfy the requirements based on the code and the regulations that governs the Jamaica rum GI registration. So it is open to persons to use. That's the thing about GIs, they're inclusive. You can be a member, you can use it so long as you abide by the standards, the guidelines set by the registration of the geographical indication.
Okay. Very interesting indeed. Um,
Mm,
I learned too that in as it relates to honey,
yes.
depending on where in the island the honey is produced, it tend to have a different
Flavor,
um,
taste, yes.
flavor, taste.
Mhm.
So that could be a GI as well.
Only if it's the name of a place. So one of the things though, and very importantly, a GI is not created. It is recognized. So it is something that has been going on for many years.
Okay.
So, like our Jamaican ginger, our Jamaican pepper, and other areas that we have been accustomed to over the years for certain quality, etc. Our jerk has been around for many years. Jamaica jerk has been around for many years.
Yes.
Our rum has been around for many years. Certainly so for Blue Mountain Coffee. So you wouldn't get up and create a GI because you have to prove the connection to that product and the
Okay.
local. All right. But if certainly you have a honey that comes from a particular geographical area in Jamaica, then that name could acquire geographical indication status so long as you're able to satisfy the requirements on the GI under the GI Act. So you have to be able to show that the product is linked to that particular area and it acquires certain characteristics from that particular area. Sorry, I remember some time ago someone applied for logwood honey as a trademark. And these are some of the things that, as a registry, we have to be careful and always are. We try to be as best as possible in ensuring that names that are supplied for registration are deserving of being owned exclusively by one entity or one person. Because, as you can imagine, if the registry were to give an entity exclusive right to a name that they ought not to,
Yes.
then that poses a lot of challenges for persons
Right.
who want to use his name. So generally, names that are descriptive or they are generic in relation to that trade or sector are prima facie devoid of distinctive character. You can't get exclusive rights to those names. Once they're generic, in that trade or sector, or they are descriptive of the goods or the services in any way. So logwood honey was a type of honey where I understand that the bees would feed on the logwood, and the logwood, as you would have just indicated, would give the honey a certain flavor or taste. All right. So that one person could not have been given exclusive
No,
rights to logwood honey. If you wanted to say Serenity logwood honey, then you should be able to say that. If I
that's
want to
it.
say Herman Dawson's logwood honey, then I should be able to say that. So just re-emphasizing the point that your trademark must be distinctive. It must be able to distinguish your goods and your services. So it must not be descriptive, and it must not be generic for those goods or services.
Okay. Wow. We have covered a lot in the hour, and really interesting. And I trust that the viewers who are watching live or going to be watching the rebroadcast will pick up on their specific area. But something though, because I noticed a number of persons are doing like t-shirt lines and all of that. Whatever
Right.
they put the, because I think you mentioned earlier in terms of specific images, the quotes and all of that, they can have those. Um,
Right.
right, they can do their usual copyright, because they, once they do the copyright of whatever area they did the copyright under, they're free to use that on anything because they have
Right.
rights to the quote.
Right. Well, if it's a quote, copyright doesn't protect a phrase. So if it's in relation to a quote, you have to be very careful as it relates to whether you have copyright protection for a quote. Um, is a quote a work? It may be, you may have to rely on case law to decide whether a quote can be protected. I know certainly there's a case for Exxon where Exxon was trying to rely on copyright law for protecting the word Exxon, and the court did not agree where that is concerned. So
Okay.
a number of words themselves may not be classified or may not qualify for copyright protection. All right, as I said, a poem certainly would be. All right,
Yes.
so there must be some sort of intrinsic value that comes from the work. It is left ultimately to determine whether the quote can be protected under copyright law. As I said before, the case for Exxon, the court didn't agree that the word Exxon was protected under copyright law, but certainly a trademark. So what we find under design law, if you come up with certain uh, phrases or how you write, because design doesn't protect the words themselves, it protects
Oh,
how it
it's
looks.
the
All
look.
right,
Oh,
it looks.
okay.
All right, so if you come up with common phrases, for example, and you put them on your shirt, it's how you represent them. So there has to be some unique way in how they're expressed or how they're looking. That gives you design. That may give you design protection. But we have certain phrases that are out there that you can't claim exclusive rights to. All right, but the copyright law wouldn't protect the phrase. And I believe to some extent the quotes would be certainly questionable as to whether they attract copyright protection. But certainly you can register quotes as trademarks as long as they're distinctive. So
Okay.
slogans, for example, have been registered as trademarks. One of my most famous slogan is freshly picked water. I'm not sure which company has it, but it's freshly picked water. And you can see how distinctive that is, because how do
Oh,
you pick
yes.
water? All right.
Indeed.
So you can have slogans being registered as trademarks. So if you have a quote and you want to protect it, maybe the best area to look at is protecting it as a trademark. But for trademark, it has to be tied to goods or services. You can't register a trademark in thin here and have it protected for everything unless you apply for all 45 categories under the NIS classification.
Okay.
All right. So work under copyright, you can have protection for it. So if you have a photograph that you take, automatically you have copyright protection for that photo. If you put that photograph on a bottle, then it may attract design protection to that bottle, and you can register that bottle under design law. All right. So you
Right.
can have design protection for that. So persons who are creating t-shirts, not the quotes, again, it has to be written in an original and unique way for it to be considered original and novel. But if you come up with different artworks that comes on the shirt, you can register as design protection. All right. But that same artwork can also be relied for for protection under copyright law. All right. So in one
Right.
work, you can have multiple areas of law for which protection can be afforded. All right. Depending on how you want to do it, you can have rely on copyright protection, which again there's no registration that is required. But if you apply it to an article, because design protects protects the shape and look of an article. If you apply it to an article, then you could apply an acquired design registration for that article with your particular design on it.
All right. I'm sure our creatives will be doing some research and checking to see how they're going to protect their rights.
Mm-hmm.
And of course, they can go to
Yeah,
jipo.gov.jm. Did I
right.
get it
That's our
right?
website, JIPO, jipo.gov.jm. Yes.
All
Yeah.
right. And you'll get all the details there, including the contact information. So you can get additional details on how to go about protecting those rights. And
Certainly.
we see our social media seeking to protect some of those rights as well, because some of those music that we want to play because we love them so much, we have to
Right, right, right.
we have to be mindful of the rights of others. Sir Dawson, it was a pleasure having you on. Do you have any final words before we wrap this episode?
Right. It was a pleasure as well being here and sharing. It's always important for us to encourage our creatives, rights holders to one, get protection before it's too late. You know, we have seen so many situations where persons did not register, and then it really becomes a real pain to try and run and catch up to get your rights protected.
Yes.
So we always say to persons, if you have something, you need to show ownership, similar to where you have your house, your land, your car, you have your title. Then if you have intellectual property, you
Yes.
want to have a title, so get your registration certificate to show that, okay, yes, I am the rights holder for this particular piece of work. And importantly, if you're seeking to pursue criminal proceedings, or for the police to um, pursue criminal proceedings, then you have to have something to show the police. There's an IP unit of the organized crime division that will deal with intellectual property infringement. So if you realize someone is using your trademark or your products, you can go to the IP unit of the JCF, and you need to show them your certificate to show that, okay, these are my registrations and they're being sold in this particular place, so that the police can start proceedings against these persons. You can't go to the police and tell them that I have something, and you're not able to prove to them that you own it. So you need your certificate as proof of ownership, so you can bring that to the police. And again, if you're going to start civil proceedings in the court, then your attorney will need a certificate. It's the easiest thing. However, you can try and prove that you have rights to a particular name at common law. And common law, we're talking about usage. In the absence of having a registered certificate, you can use evidence to show that you've been using it over time, and your attorney could be able to make a case at common law. But that is more tedious. If you have your registration, it's simple. You show, and then you try and you use that to enforce your rights. So again, always seek to try and register and get your certificate as proof of ownership, so you can enforce the rights in your brand and exploit your brand as well and your products.
Awesome. I'm so glad I allowed you to share that additional thought, because that's very important in terms of where to go if once you detect that your rights been infringed on. That point about there being a specific unit in the JCF that deals with that. Just as you have a unit that deals with cybersecurity, you have one that deals with your intellectual property.
Certainly, certainly.
That's great information, and I trust we all got that. So many nuggets. I certainly learned a lot more. Although I've been dealing with copyrights over the years, there's always something new, and that's why it's so
Right.
exciting here on the Resource Connector. Because as I share with the viewers, I myself learning more, and I enjoy learning.
Certainly, certainly. It's true.
Thanks again. Please extend thanks to your the team there at JIPO. It was really great for you to be here to share, and we're looking forward to more conversations, because with so many changes taking place, I'm sure you're going to have additional information to share as we progress, because there's
Right.
a absolutely different areas depending on the entity that you're in and how the implications. So thank you.
You're
This
welcome.
has been another episode of the Serenity Resource Connector, and you do not want to miss the next episode as we continue to provide you with guidance. We're still focusing on the startups, entrepreneurs, solopreneurs, wherever you find yourself, focusing on that, virtual hand holding, taking you through the process, what you need to know before you start, what you need to do in terms of getting registered. We just talked about protecting your rights and respecting the rights of others, just as we want them to respect our rights. Right. So, that being said, next week we go into another area, but stay tuned. We'll share what it is that we're going to be looking at. So set the time. I believe next week we're all on the same time in the US. So it's going to be 3 p.m. local and in the United States as we continue our public education, having conversations with another government entity or service providers. And remember, don't forget to share. The sharing is caring. God bless you and continue to stay safe. Thank you again, Sir Dawson.
You're welcome. Bye bye.
Okay.